Welcome back for the second segment, and thank you for staying with us. Our keen focus is what transpired yesterday evening at the Milimani Law Court, where the High Court upheld the impeachment of former Deputy President Rigathi Gachagua, ruling that the process followed the National Assembly and Senate was lawful and that the final outcome remains valid under the Constitution. Now, what we want to look at is the implication of this particular ruling, even as the DCP party leader, that is Rigathi Gachagua, has vowed to, of course, appeal this particular decision at the Court of Appeal, even reaching the heights of the Supreme Court. Now, some of the key issues that came out yesterday of that particular ruling is the process that the National Assembly went through to ensure that Professor Kithure Kindiki takes over from the former deputy, that is Rigathi Gachagua, following his impeachment. Also, the High Court upheld the process through which Kithure Kindiki was nominated and approved as the deputy president. Also, the other issue is on the public participation that was carried out by the National Assembly, which the courts verified that it followed the due process, and also the court awarded Gachagua 50 million shillings in damages after the High Court found that his constitutional rights were violated during the impeachment proceedings, particularly when the Senate declined to grant an adjournment he had sought. Now, the 50 million will be coming out of the pockets of the Senate to the DCP party leader. Joining us right now to make a sense of the ruling and the implication it will have, especially even political implication ahead of the 2027, is none other than Gibson Gisore, a constitutional lawyer. Gisore, karibu sana, and thank you for joining us.
Thank you, Abdi, for welcoming me to this particular show.
Yes. And maybe, Gisore, given that you're a constitutional lawyer, and this is the High Court, because the High Court deals with constitutional matters itself, what did you make of this particular ruling?
Two things. For me, what is key is, as you have indicated, that this is the High Court which deals with constitutional issues. I expected a more elaborate judgment, which had very merited findings, but unfortunately, to my end, I have to say that to some extent, it fell short of that. And on the other side is the aspect of the constitutional delimitation of the right to fair hearing, which was clearly articulated that the Rigathi Gachagua's right to fair hearing were indeed violated when he went to hospital, and the Senate was informed of the same, but they still just proceeded with the proceedings. That violated his right to fair hearing. Essentially, from a legal perspective, if somebody says that, Abdi, your rights were violated, the court should have downed their tools there and should not have said anything more, because that is a constitutional right which is held paramount in our constitution. Once that is violated, you cannot go ahead again and say, or the court ought not to have proceeded and said that nonetheless it could not have vitiated the right, the perspective of the proceedings. That in itself brings contradiction, and that lays a ground for appeal for Rigathi Gachagua, so that the Court of Appeal and the Supreme Court, if the case may be, can be able to determine on those issues. But from where I sit, I think that they handed him a right to proceed to the Court of Appeal, which indeed they understand they have filed a notice of appeal. So that should be able to give another round of litigation. What is a bit disappointing is that this is the High Court which should be able to follow the Constitution to the latter, but much as they found, then I think going ahead and saying it could not be able to vitiate, then now creates another question. What is the threshold for one's right to be affected, or to be said to be affected in terms of fair hearing? If you have not been granted a fair hearing, essentially, through court precedents and the reading of the article on the right of fair hearing, clearly demands that the court should be able to find that the process was null and void. But in their wisdom, they decided that that was not enough. An award of 50 million could be sufficient because the aspect of damages cannot vitiate your right to fair hearing. I think that in itself sets a very dangerous precedent that now gives the state, or for example the prosecution, the prosecution could be able to go ahead and deny you fair hearing, and then the courts will say, yeah, no problem. I mean, nonetheless, yes, they were wrong, but still it's okay that you were charged. And then they say, we can award you some small money for that so that you can go home and rest. You see, that now gives, creates a transactional way of dealing with the right to fair hearing, which it shouldn't.
And normally, explain to a Kenyan who's listening to us right now, once they go to the Court of Appeal, will they go back through the tedious process of explaining what transpired from the start to the end, or will they be talking about the judgment, which are clearly stating the contradictory element of it in terms of fair hearing and what the judges decided at the latter? So what issues will they be looking at from the start, or the ruling that was made by the three-judge bench?
They won't, of course, yesterday was a tedious day for 10 hours. Our judgment was being read. I understand it was 350 pages. But now when it moves to the Court of Appeal, it strictly deals with the issues of law, which were said to have been affected. So those points of law are the only things which will be raised in the Court of Appeal, and then they will be able to be litigated upon. See, that is essentially the rule of appeal. When you are appealing, you don't appeal on the facts, you appeal on the rule of law. And the rule of law here is really the constitutional provision on fair hearing, which was affected, and the aspect of award of damages in exchange of declaring the process to have been null and void. There are other issues, legal issues being raised on the aspects of whether there was actually even a petition to be presented, was an impeachment declaration to be issued by the Senate. That I've seen the lawyers for Rigathi Gachagua try to raise the issue, but that will be able to know concisely when we see the notice of appeal. Since I've not seen it, but I've heard that they filed. Once I can have access, then I can be able to clearly delineate the issues. But essentially, all the issues which are appealed at the Court of Appeal are legal issues. You don't go to issues of facts or other issues which came up during the ruling. So we expect that in the appeal, the issues will be narrower, the issues will be more direct, and the issues will only be constitutional issues. And this is important because the trial court gets to listen to everything. And essentially, when the trial court listens to everything, then it comes up with issues. In this case, the court was able to come up, I think, with around 7 issues to which were narrowed. After they came up with these 7 issues, now out of these 7 issues, what are the constitutional issues which arise out of these 7 issues, and which constitutional issues, because you cannot be able to appeal on everything, even the ones which they rightfully declared or found they found on merit. You only specifically point out the issues of contention, so that the Court of Appeal has an easier time in terms of deciding what the contest is. And it's designed as such so that you don't relitigate at the higher court. You only say, these are the issues which I don't agree with the judgment at the lower court. Kindly look at these issues so that for clarity, and secondly for purposes of fair hearing and for purposes of justice. Yes.
And Gisore, we have been talking to you even in the past. We have witnessed several impeachments, especially for governors. We've never witnessed for a deputy president, and this is the first time we're witnessing it. So in terms of precedents that it has set yesterday in the High Court, what will it inform further impeachments if there will ever happen, it will ever happen again down the line?
This is quite interesting, Abdi, because interestingly, this is the first one we have ever had of an impeachment of a deputy president of this magnitude. We've not had of a president, we've not had, so this kind of set the pace for what to expect. So that is where we, as lawyers, we are trying to insist, let the judgment be as clean as his wife, so that in the future, if we are going to rely on this, we have a clear precedent on the same. If the judgment is full or is marred in issues of confusion in terms of the direction it's giving, then it sets a very bad precedent even on the other impeachments You remember we've had a couple of impeachments of governorship. Then this will be now the mark which they will be using, the threshold which they will be using. So it gives rise to absurd judgments which are going to come out of the courts if they are going to base their judgment on the declaration which was given yesterday. I'm not entirely condemning the judgment, but my point is that the judges came or fell short of giving a clear direction on the terms of fair hearing. And fair hearing, you cannot be, under our constitution, you cannot be able to give two directions on the same. It's understood, or it's a well-settled law that fair hearing, once your rights to fair hearing have been affected, then the charges become null and void. So you cannot say that the process could not have been initiated once the process, once you've already found that the right to fair hearing was affected. There was no rush, nobody was dying. They could have just waited so the process should be able to proceed. But the hurry in which they moved to effect the impeachment is what is in question.
And in terms of public participation, which I know the legal minds, especially in the corridors of justice, you're speaking about it. So in terms of what the court relied to ensure and say with definitively that there was ample public participation, do we have a law in place already, Gisore, that guides that notion?
We have not come up with a policy on public participation, but nonetheless, the Constitution itself is self-speaking on that aspect, and the courts have labored a lot in terms of coming up with the directions under which you can be able to use that to delimitate whether there was ample public participation. To the case of Gachagua, they said that there was ample public participation, in that there was sufficient time which was given according to them. There was also the aspect of use of several aspects or platforms for public participation, and that in itself, according to the court, said that that was a sign of goodwill, that they wanted to get the views of Kenyans. But from where I sit, I think such an aspect of such magnitude, because that's like a presidential petition, ought to have been, you see, those are discussions which you can be able to have. Even presidential petition, you see the limitation is 7 days. There's been an argument that let it be given a month, or let it be given at least 3 months, for purposes of the lawyers having enough time to collect evidence, to collate even the evidence itself, because it almost becomes like an assembly line to process evidence for presidential petition. So akin to the Rigathi Gachagua proceedings, we should have expected a longer process, which, but those are discussions which you can have as Kenyans, whether we can be able to relook into our law to be able to, so that, you know, issues of seriousness, there should be no rush. There should be a due process. There should be sufficient time, because the article on the Constitution on fair hearing demands that you need to be given sufficient time. But according to the court, in their wisdom, they said that that was sufficient time. The jury is still out whether that could be the case. But nonetheless, it's something which is continuously under review. You remember, even under the Constitution, under the Finance Act of 2023 and 2024, there were issues, and the Supreme Court itself gave directions on aspects of the same, so that affects even any other decisions for the lower courts. So I think every decision which comes up in line of a specific agenda affects, especially from the superior courts. That's why we are insisting that going forward, let's have a clear, because we are seeing a dangerous, we are heading down a dangerous road if we hold that the right to fair hearing cannot vitiate a process which is of the magnitude of impeachment of a deputy president.
And now, given that you wear two hats here, what are some of the political implications following that particular judgment?
The political implications are clearly set down, that the Rigathi Gachagua will most likely not be able to hold any public office for the next few years, and that essentially puts him in the cold. And that's where we are saying that this process ought to have been thought clearly. You cannot award somebody the 50 million, then you tell him, go still to prison. Go to the political, because that he's been put in a political prison. So you either condemn him fully or don't condemn him. Because if you say his rights were affected, then let that be demonstrated in the kind of decision which comes out of that. So it's important, I think, for Kenyans to understand that the right to fair hearing is such a sacrosanct process, or is such a sacro in our constitution. And for very good reason, the framers of the constitution decided that it should be so, in that previously, or the previous regimes used to use this particular aspect to deny people rights. People could be tried at night. People could be tried after a long time. People could be kept in prisons for so long. So this aspect of what Kenyans shed blood for and really fought to have a constitution which is clear, then we don't expect that the courts start giving some other judgment, a judgment which seems to be taking away from that particular right. So that is basically the long and short of the contention.
And in terms of, you clearly started, you have given us the difference between what will happen in the future and, of course, what precedents it has set. So in terms of in the future, if we ever get an opportunity to witness another deputy or even a president sitting following this particular procedure, what ramifications will it have not only on that particular person, but on the judicial system, you legal counsels, following that particular precedence that has been set by the High Court?
You see, the beauty with the court, it has a self-correct mechanism, and that is why I'm saying that there's still another process which they can be able to go to the Court of Appeal, and the Court of Appeal can be able to make a determination. Once the Court of Appeal makes a determination and still legally there could be some other legal questions, then there's still a right to proceed to the Supreme Court. Why do I say so? Right now, out of the judgment, I've seen even some senators post on Twitter and say, as we don't have an allocation for 50 million to award the former deputy president. Now, we are also going to the Court of Appeal to appeal on that award. So you see, each side, much as they say the impeachment was not vitiated, even the side which seems to have won also is not happy. So a judgment is not supposed to be conflicting in that way, that every party went to court seems to have an issue with the judgment. So that is the kind of confusion we need to clear. Secondly, the law must be able to be clearly cut in stone, that this is the direction. You cannot say this is the direction, but I mean, you can still bend it, and then still you can be compensated on the other side. So the aspects of compensation, yes, are there, but if you have found clearly that the court that the process was marred in some sort of things which touch on the right to fair hearing, as lawyers, we feel that in itself takes away the credibility of the judgment. So it's important that we move ahead, or we move quickly to the Court of Appeal to make a clear determination on those contested issues, and to be able to lay the process of the law clearly.
And we have been hearing even from the senior counsels who are representing not only the National Assembly, the Senate, even Rigathi Gachagua, they were talking about this is a political process. With a judgment in hand, and of course the judgment that was given that the lawyers and the politicians out there are saying this is a political process, how do you marry two and differentiate at the same time when giving a direction such as this?
I think that is where could be the judges maybe were able to weigh in more on the political side as opposed to the legal side. The interesting mix then is what is bringing all these problems. You see, even when you are making tea, sometimes there could be a lot of milk, sometimes there could be less milk, sometimes the tea leaves could be could be more stronger than. So that is what we are talking about. That mixing the two, it becomes a very tricky process for anyone, but we don't expect that to happen at the High Court. That in itself is like, you can't expect that from a professional chef who has been able to be in the kitchen for so long. He doesn't have a right to get it wrong. Why do we insist on that? The reason why we insist on that is because a lot of work has gone into this over the years, and Kenya comes from an historical perspective. So we don't expect to have a declaration such in the High Court, which brings confusion, as I've already highlighted, that even the side which was impugned already is contesting, and the side which ought to have been celebrating is also saying, no, we are also not comfortable with that. There are some aspects which we feel we were wrong. So there needs to be clarity. Yes, there is always a chance that the courts will be able to find to make a decision or a finding which affects both parties who appeared in court, but not the one which touches on the substratum of the Constitution. The bedrock of the Constitution of Kenya is the article which talks about fair hearing. And once that is affected, every lawyer of any of what is sold ought to be alert, and then we need to have a clear determination on the same, not for anything, not to credit whatever process which happened or to critique it, but for purposes of the entire decisions which are going to come thereafter.
And of course, during the weekend, even the DCP party leader, Rigathi Gachagua, clearly stated that he will accept whatever outcome will come out of that particular judgment. Now that the die has already been cast, he will go through the Court of Appeal. If he decides, he'll go to the Supreme Court. But politically, are we possibly going to see realignments within the united opposition following this particular judgment?
Politically, I expect, I saw quite a number of the United Opposition Alliance members. They were actually sitting listening to some clips online on the same. I think I saw Eugene Wamalwa, I saw Kalonzo Musyoka,
yes,
trying to give him support. So as to whether that will materialize into something concrete, it's something which we can be able to give time to be able to determine the same. If that process in itself, you see, wanasema, you see in Kiswahili they say, mwenzako akinyolewa tia yako maji. So that process itself can affect anybody. It's not only an impeachment, can only, as I've said, that decision is going to be now, if it's not clearly cut to the standards which the Constitution anticipates, it's going to affect a lot of other things. Because as lawyers, the way we do our profession is that we rely on courts of superior, the courts of superior decision. Those decisions become binding on the lower courts. So do you imagine, and that's where the bulk of the work is done, relying on an absurd judgment or a judgment which falls short of the threshold of what the constitutional aspect is. This will affect criminals who have or accused people, not necessarily criminal, accused people will be affected. This will affect people who especially file constitutional petitions, because now they will say, this is the standard which has been set. Your rights might be taken away, but then nonetheless, the party should be able to, the people have, especially when it comes to issues of government vis-a-vis the people, then that becomes very dangerous, because government is all powerful. It can be able to pull things. It can be able to decide to take a move on a certain position. It's important that under the checks and balances, we have an equally balanced process, which is given under the fair hearing article, which talks about somebody ought to have been given sufficient time, given enough materials, given enough opportunity to defend themselves. But now when a court finds that indeed Abdi was not awarded sufficient material, sufficient time, or his right to fair hearing was affected in one way or another, as a constitutional court, because the High Court is a constitutional court, it's expected that they ought to have clearly made a decision or a guideline that this process was null and void. It's interesting, of course, there is an argument from both sides, that from the other side, that you see it could have given rise to now having two incumbents in the office of the deputy president. The deputy president himself had dropped the prayer just before, during the hearing. He had dropped the prayer for being reinstated, for being reinstated. So that in itself, of course, set a trap for the court. It set a trap for the court, and the court ought to have considered that exceedingly carefully to ensure that we don't end up where we are, where every party is rising and saying whichever judgment was given, even as we are appearing before the Court of Appeal to appeal on some of the issues. Yes.
And in terms of drawing contrast, because there were some arguments yesterday after that particular ruling, that if I was impeached when I was serving as a governor, can I use that judgment to outweigh whatever happened to me, given that I appealed it to the Supreme Court? Can I go back to the High Court with a new perspective, with the lawyers now targeting from what the precedent has been set by the High Court yesterday?
No, somebody already impeached was already impeached. You cannot be able to use the judgment retrogressively. So the cases are decided on the facts presented, because the facts under which this decision for impeachment of Honorable Rigathi Gachagua were given might not be exactly the same as the circumstances under which somebody was impeached. But now, if somebody indeed was maybe impeached on grounds of maybe his fair hearing was affected, that in itself, for now, the future cases which are coming up, then they can be able to make a case in court that, you see, the court in Rigathi Gachagua petition said this, that such decision can be able to bind. But now, for former cases, it will become a bit tricky to file a suit, because that is already, there's something we call functus official. When a matter is functus official, then that the court's your rights or whatever decision becomes official, and then you cannot be able to revisit it. Especially if somebody went all the way to the Supreme Court, then this is just the High Court. They still, Rigathi has an opportunity to still go all the way up to the Court of Appeal and then to the Supreme Court. So whatever decision which the Supreme Court, if at all they end up there, will be able to be given, that becomes binding on all the courts in Kenya. That becomes the norm of deciding cases of a similar nature. But if somebody went already was impeached and went to the Supreme Court, a decision was rendered, he cannot come back and rely on this and say, now you relook at my case also.
Give us your final remarks, Gisore, in terms of what is next now for Gachagua.
I think for Gachagua, it's clear he's going to the Court of Appeal, and even if he was not going, it would be my advice that he goes, because not for himself or not for this particular issue, but for purposes of setting the record straight in terms of coming up with a clear-cut decision which can be able to now be used in subsequent cases of similar nature, so that we don't end up having judgments which will be able to give rise to issues of either party saying, I'm not so sure whether the court ruled in my favor, because even if they did, still I feel they fell short of something. A judgment should not be ambiguous. A judgment should be able to be clear to anybody who is reading it or anybody who is being told, especially to the parties. Yes.
Thank you so much, Gibson. Always a pleasure. Thank you for making time for us. That is Gibson Gisore, a constitutional lawyer, of course, following that particular judgment that was made yesterday evening at the High Court. And of course, we'll be getting more reactions to it and we'll be sharing them with you in our subsequent bulletins. That concludes News Check today. Of course, do join us next week, same time, same place, of course, to discuss issues pertaining to what is happening in the country and beyond our borders. My name is Abdiaziz Ashim. Don't go too far. Kasichana Masha is up next with Kurunzi Mashinani. Good morning for now.